Legal Speed Series Dictation number 2. 5, 4, 3, 2, 1, start. The tribunal, relying upon its earlier judgments, held that the disciplinary authority alone can initiate a disciplinary proceeding against a government servant under Rule 3 of the said rules, and as the charge memo in this case was issued by an officer subordinate to the disciplinary authority, the entire disciplinary proceeding stood vitiated. The tribunal also held that the applicant wanted a railway warrant to enable him to appear before the medical board, and as the same was not given to him, he cannot be said to have disobeyed the order of a superior authority. For that reason, and also on the ground of absence of any provision under which non-appearance before a medical board can be considered as an act of misconduct, the tribunal held that there was no justification for initiating a disciplinary proceeding against him. The tribunal also held the inquiry officer by denying his request to have the documents which he had asked for, and for perusal of a file had deprived him of a reasonable opportunity to defend himself. The tribunal also held that as the applicant was not given a copy of the inquiry report, and as the order was passed without giving him a further notice, his dismissal has to be regarded as bad. The tribunal therefore quashed and set aside the order of dismissal. The state has therefore filed this appeal. The learned counsel for the state submitted that the view taken by the tribunal that only the disciplinary authority can initiate a departmental proceeding against the delinquent government servant is contrary to the law laid down by this court. This point is covered by the decision of this court, and therefore the contrary finding recorded by the tribunal will have to be set aside. Stop. The learned counsel for the respondent has fairly conceded this position. The view taken by the tribunal as regards the effect of non-furnishing a copy of the inquiry office is also contrary to the law declared by this court. In this case, the order of dismissal was passed. Therefore, the tribunal could not have nullified the order of dismissal in view of the judgments of this court. The third reason given by the tribunal, that there was no justification for initiating a disciplinary proceeding against the respondent, is also not sustainable. The proceeding was initiated against the respondent for his indisciplined conduct in disobeying a lawful order passed by his superior officer who was competent to pass such an order. The respondent was transferred and was posted as sub-inspector in charge of the police station. After joining duty there, he proceeded on leave and continuously remained on leave till he was called upon by the superintendent of police by passing an order to appeal before the medical board. Stop.